Good afternoon, everyone. Leonardo Cardoso de Magalhães, who is our Federal Public Defender General, couldn't make it to the panel today, and he's really sorry about that. But he sent me his opening speech of this panel, which is a wonderful panel, and I'll share his speech with you. So it is a great honor for the Federal Public Defender's Office of Brazil to take part in this important dialogue with the representatives of the Hague Conference on private international law at such a decisive moment for strengthening global governance over the carbon market and other instruments of the green economy. The DPU has been monitoring on the ground the social and environmental impacts of carbon offset projects and extractive activities, particularly in indigenous, quilombola or traditional communities, and other alternative communities. The absence of a robust international legal framework in this area has generated legal uncertainty, power asymmetry, and risks of human rights violations, including those affecting vulnerable groups. Our view is that the development of regulatory framework in the field of private international law should be grounded in the pillars of transparency, traceability of transactions, shared responsibility, and transnational access to justice. The DPU has been structuring its work in the field through initiatives such as the National Observatory on Mining and Social Environment Effects, the OGES, and the Advisory Office for Environment, Climate Change, and Human Mobility, both aimed at strengthening institutional responses and dialogue with international organizations. Furthermore, we are pleased to inform you that the DPU will coordinate a gender session at the United Nations Forum on Business and Human Rights in Geneva, immediately following this COP30. This issue is also central to the debate on the carbon market. Women, particularly in rural and traditional communities, face disproportionate impacts of climate change and continues to encounter systemic barriers to land, income, and decision-making. Integrating a gender perspective is therefore essential to ensure a just, inclusive, and truly sustainable transition. For these reasons, we believe that this dialogue can contribute to concrete legal innovations that reconcile regulatory security, gender equity, and climate justice. The DPU remains fully available to cooperate technically and to share Brazilian experiences that may help strengthen this international legal framework and promote access to justice in transnational contexts. I thank all the authorities present here today, and I thank the audience very much for attending this important dialogue. I'll turn to Raquel now.
Thank you. Thank you, everyone. My name is Raquel. I'm a legal officer at the Hague Conference on Private International Law. I'm now just speaking in the role of moderator and to introduce our panelists. We are doing this discussion in English, but at the end we will have a space for debate. And of course, we can then, I'm Brazilian, we can also speak in Portuguese and have questions in Portuguese. I try to make that bridge if that's helpful. Right now, so we continue in English, and I will just introduce our first speaker, who is the Deputy Secretary General of the Hague Conference on Private International Law. I will read the bios of the speakers so you also get to know them. And Dr. Geraldine Escolar is Deputy Secretary General of the Permanent Bureau of the Hague Conference on Private International Law. She's also the head of the International Commercial, Digital and Financial Law Division which includes, among other portfolios, responsibility over the Hague 2006 Intermediated Securities Convention, the 2015 Principles on the Choice of Law in International Contracts, the Experts Group on Central Bank Digital Currencies, the Experts Group on Digital Tokens, and including other work, but in particular, the work on the Experts Group on Carbon Markets. She's also professor at the Faculty of Law in the National University of Singapore. Dr. Geraldine.
Thank you very much, and a very good afternoon to everyone. First, thank you so much to our very kind hosts, the Public Defender's Office of the Union of Brazil, and in particular to the Public Defender General and his representative for being with us here today. Thank you for your hospitality. Thank you also to my co-panelists. It's a privilege to be here with you. And thank you to the audience. I've been here for this week, and you have so many events at COP. I want to be everywhere. I have FOMO for everything, and I'm so pleased that you've chosen to spend your time with us. So thank you very much. Now, I'd like to maybe talk about something which is interesting to us, which is really justice across borders. I'm going to try to speak as slowly as I can, which is not very slow, and I tend to get very excited about things, and when I do, I start to speak really quickly, so I apologize. If it doesn't make sense, tell me and I'll say it again. But let me start first with a story, and with one example of many examples where the carbon markets can actually help individuals. This is what my organization does, okay? We really look at helping individuals and businesses and entities across borders. So here, this is one story with a bunch of different complexities, but an interesting story as to why carbon markets can help communities, people, especially local and traditional communities. So a few years ago, the Yurok tribe in Northern California became one of the largest participants in the global carbon market. Now that's surprising. Why did they do that? They did that for one very simple reason. They wanted to buy their land back, their ancestral land. So what did they do? For generations, that land had been lost. It had been lost to logging companies, to state pressure, to financial constraints. And the forests were degraded, the salmon habitats were collapsing, and carbon finance provided an optional way out. What were they doing? By restoring forests, by protecting them from further degradation, the Yurok tribe generated carbon credits, which were then purchased by other actors. And with that money and with that revenue, they bought their land back. They restored the ecosystems. They revived the stewardship practices that they've had for generations, hundreds of years. And that had shaped their culture. They managed to revive that, and through participation in the global carbon markets. What's special? This is a local community. This is a vulnerable community participating in a global market. This is a cross-border transactional issue. And here is the crucial point. The project was successful in that case, but the success of that project depended on legal rights, obligations, relationships that stretch across jurisdictions. It was not just California, it was not just the United States. And these local communities were engaging really with the global trade and global community. What did it depend on? Enforceability, legal clarity, certainty. And this is where private international law steps in. This is what my organization does. Now, this is a pattern that we are seeing repeated across the world, across regions. We're consulting, we're seeing it here in the Amazon. We're seeing it in Southeast Asia, where I come from. We're seeing it in the Congo Basin, in the Pacific, and East Africa. Some communities turn to carbon projects, not because they want exposure to global finance, but why? Because they want stability for their livelihoods, protection for their lands, resilience against climate impacts, and recognition of their long-standing stewardship. That's why they do that. But yet, the moment that a project enters a cross-border situation and the activities leave the home jurisdiction, these communities then encounter foreign laws, foreign registries, foreign contracts, foreign dispute pathways. What happens? Their work is local, their legal exposure becomes global. And that's why private international law frameworks matters. I'll keep saying this, and the question is, what is this private international law thing that I'm speaking of? It's really three very deceptive, simple questions. These are the three questions. First, which country's laws apply? When you have two jurisdictions or two countries, which law would apply? Why should that law apply? Second, which country's courts have jurisdiction? which is the correct court to bring that dispute? Why that court? And third, when you finally get the decision, is it worth more than the paper it's printed on? Will it be recognized? Will it be enforced? Especially where the decision actually matters. Now, these questions will determine whether local communities can enforce their rights. It will determine whether public policies can be upheld, whether harm can be remedied, and whether justice is actually reachable. That's why it's so important. Without private international law, justice stops at the borders. With private international law, it carries on. Why is this important? Carbon markets do not stop at borders. It is a global phenomenon. What do we do? My organization is the Hague Conference on Private International Law. We have a short form, we call it HCCH, it's not easy to say. But what we do is we enter the picture and we help countries develop global frameworks for these questions: jurisdiction, choice of law, the recognition and enforcement of judgments, and cooperation between authorities. These are rules that make justice accessible and makes justice travel. Now, the HCCH is finally now applying this expertise to one of the most complex, globally integrated systems humanity has ever built, the carbon market. And this is actually the Carbon Markets Project. Now, I won't look too much into it because we have the chair of the Carbon Markets Project sitting right next to me on my right. But our project starts upstream and looks at land and resource rights, benefit sharing, communities, and so on, through midstream, all the MRVs, monitoring, reporting, verification, registry operations, down to downstream, with tokenization, collateralization, and securitization. It also touches on Article 6 mechanisms and activities beyond Article 6. That includes the voluntary markets, RED+, nature-based biodiversity credits, and decarbonization. At every stage, the question we ask is the same. This question is, what is the legal framework applicable to these cross-border relationships and activities? Now, in Article 6, of course, the significance of private international law is even more obvious. For many years, Article 6 lived only in negotiation rooms, but now no longer. With the adoption of the rules for Article 6.2 and Article 6.4, it's moved from negotiation to implementation. What does this mean? Countries will now be building registries, authorization systems, adjustment workflows, reporting structures, and now we're starting to see a growing convergence between the compliance and voluntary markets, which means that in this context, a mitigation outcome can be generated in one jurisdiction, authorized in another, recorded in another jurisdiction's registry, and then used in a fourth jurisdiction for compliance. So, this system, of course, cannot function without private international law. What's most important, however, is that the cooperative approaches of carbon markets rely on trust, and trust requires enforceability. The legal infrastructure that private international law provides is a crucial enabler that allows the actualization of climate ambition. So why is this important? This also brings us to one point, which is that private international law must be multilaterally and inclusively consulted. So this is the thing. Private international law for carbon markets have to be co-designed. There has to be inclusive and sufficient consultation because private international law cannot be drafted by a small group. It must be developed multilaterally with inclusive global consultations, time for discussion, input from local and traditional communities, input from standard bodies and registries, and the involvement of governments and technical experts. Why? Because carbon markets involve asymmetrical actors. There's not an even playing field. They all have different capacities. Second, private international law rules affect all actors, whether or not they're consulted. So let's consult them. Third, communities must shape the rules governing downstream financial structures because they are built on their ecological network. Fourth, climate ambition involves every country in the world, and so implementation must carry that multilateral legitimacy. And five, and most importantly, without inclusive design, trust collapses. And without trust, the carbon markets cannot scale and cannot scale responsibly. This is the reason why, with our consensus-based mechanism, we're trying to get inputs from communities and ensure multilateral discussion to enable this framework to work for you and me, for all the communities around us. Now, across regions, communities participate in carbon projects because these projects protect ecosystems and provide stable incomes and build resilience. But in return, they require clarity, fairness, enforceability, and real access to justice. The communities don't seek special treatment, they seek fair treatment and legal systems that they can actually access, which means that true access to justice is not rhetorical, it must be practical. So we need to ask these questions. How do we ensure factors that determine which courts are appropriate to hear disputes relating to carbon markets? This must include a consideration of the substantial connection to the land, to the project, and to the community, and not only to bargaining power. The applicable law, so what law applies to the carbon market transactions, must reflect a consideration of connections to where the mitigation activity occurs, where the land is, where the impact is felt. And crucially, the law must be able to look through the credit to the underlying project. Third, a judgment is only meaningful if it can be enforced where the responsible party is located. And so these are the pillars of accessible, real cross-border justice. So I'm going to quickly just end here. I just want to return to our story. And whether we speak of the Yurok tribe in Northern California or the local and traditional communities in the Amazon, their climate contributions are immense. Their motivations are rational, they are responsible, but once they enter the carbon markets, global carbon markets, their rights depend on legal systems that cross borders. A transition that does not extend justice, including to vulnerable communities and across borders, is not a just transition to a global green economy. And because it is not just, it will not be durable. That's why private international law ensures that rights can be enforced, remedies are reachable, and obligations have real meaning, and justice travels with the same speed and scale as carbon markets do. So a just transition, we believe, requires just law, and private international law is that vehicle that makes that possible. I'll stop there. Thank you very much for your attention.
Thank you. And now, just a quick note that we know that our panelists are rushing and they might need to leave because they are also participating in negotiations in the Blue Zone. But I will now give the floor to Mr. Eduardo Silva Bessa. He is currently the Deputy Director of the Division of Environment, Climate Change and Oceans of the Ministry of Foreign Affairs, of Chile. He's the chair of our experts group, the Hague Conference Experts Group on carbon markets. And he has coordinated Chile's negotiations on the Article 6 mechanisms of the Paris Agreement and has more than 20 years experience in international affairs and international environmental negotiations. Mr. Silva Bessa.
Thank you. Thank you very much, Raquel, Jardine, Juliana. It's a pleasure to be here. First of all, I would like to highlight that our expert group, this expert group of the Hague Convention on Private Law, Hague Conference on Private Law, is a particular one because it's the first time that the group, an expert group under this conference is chaired by a Latin American country. And that brings a new approach because, and this is not a critic because it's just a reality. In previous working groups, the participation of experts and legal lawyers has been mostly from the developed countries and from the global north, we can say. And now, under this group, we have a good balance and a good mix of experts and lawyers and decision makers from different regions. It means that we are considering different legal traditions, different legal systems, and we are trying to accommodate the different interests and concerns of the different, across the different continents and across the different regions. And as you probably know, carbon markets refers to different types of instruments or mechanisms. In one side, we have the voluntary markets, where companies, private actors decide to establish their own goals on carbon neutrality or reduction of carbon emissions. And then they use these credits to comply with those voluntary commitments. Those voluntary markets are usually organized or usually arranged by several standards that are developed by different international private organizations. No? And also we have the Article 6 markets that have been established under the Paris Agreement. They have their own rules and guidelines. And those Article 6 markets, the main purpose is to support countries in achieving their own NDCs. It means the climate goals and commitments under the Paris Agreement, and also to contribute to reduce the global emissions through additional and more ambitious climate action, creating a space and an opportunity for the engagement and mobilization of private finance. And finally, we have the compliance mechanism that are usually established in national jurisdictions, like the ETS in Europe, the carbon market in China, in Quebec, in Canada. All of them, at the end, work in this cycle of projects where we have an underlying activity, for example, renewable energies, forest projects, activities related with energy storage, and those activities then represents reductions on emissions that we can quantify. And then under a process of monitoring, report, and verification, then those activities are able to be converted in verified carbon credits. The verified carbon credits are intangible assets according legal in most of the legal systems, and those verified credits are able to be transferred across different registries, across different jurisdictions, and then in that space is where we have the challenges in terms of identifying the international private law implications that are related with the applicable law, are related with jurisdiction, are related with the legal nature of the rights on these verified credits that could be proprietary rights, contractual arrangements. All of these issues are important because to decide and identify the principles that we have to apply to determine the applicable law or the jurisdiction are relevant for the private actors because they need predictability, they need legal certainty, because they are investors, they are developers, and they are actors that needs to be assured that their own legal rights will be recognized and they will have a clear understanding of where they have to solve disputes or any other issues related with the legal rights on these verified credits. But this is one perspective. This is one issue that we are addressing in our expert group. Legal certainty, predictability, how this can promote the development of carbon markets from the perspective of the private actors. But there is also the perspective of the governments, of the public policies, because the carbon markets operates under legal systems, under different public goods, like the safeguards on environmental safeguards, the protection of human rights. And any of these activities has to be aligned with the national laws that are protecting these environmental safeguards and these human rights. We have previous experiences under CDM, that is another carbon market that was created under Kyoto Protocol, in which several projects were criticized because there were claims of human rights violations. And national laws and national jurisdiction have the responsibility, and they are empowered to protect those public goods. In our discussions in this expert group, for example, I would like to explain one of the areas where we are working about these elements. We need to identify which is the applicable law, which is the principle, how we determine which law is applicable in this cross-border activities of verified carbon credits. And because the carbon credits or the verified carbon credits are considered intangible assets and also are considered in terms of the legal nature that creates proprietary rights, usually the way that we decide the applicable law is where that verified carbon credits are registered, because we have registries. Registries like in tangible assets, we have registries to make the transfers of rights between different actors. In this verified carbon credit, we have the same. We have registries. And the principle is that the applicable law is where this registry is maintained. But the problem is that we have an underlying project. We have the forest project or a renewable energy project. And usually this connecting factor to identify the applicable law, it means the registry, is relevant for the secondary markets. I mean, all the transactions that happen after the issuance of the verified carbon credits and are related with this operation on transfer between private investors in many registries, across many registries. But it's not possible to apply this principle to the applicable law of the underlying project, because it means that at the end, a government, a country, is risking to be under the application of a foreign law, because the foreign law will be related with the registry, and that foreign law will be the regulation on issues like protection of human rights, environmental safeguards, and we need to recognize the right of the governments to protect the human rights, environmental safeguards according to their own law and their own legislation. For that reason, this principle of using the registry as the connecting factor to decide about the applicable law is correct in terms of the secondary markets, but is not right and is not useful for the underlying projects. And here, in that underlying projects, we need to recognize and protect the right of the governments and the host countries of these projects to be aligned with the national legislation. All of these discussions are the kind of things that we are dealing in our expert group. We have also all the considerations about the jurisdiction, the legal nature, insolvency, and many other areas that are related with international private law in these cross-border activities. At the end, the main purpose of our group is to have this holistic view, and where we try to accommodate different interests. On one side, predictability, certainty for private actors, and the other side, the protection of public goods like environmental safeguards and human rights, among others. This is the work that we are doing. And this is, I think, the contribution that we can make for the implementation of carbon markets that respect environmental integrity, human rights, and also environmental safeguards. Thank you.
Thank you very much. And now, yes, I'll just introduce Juliana, who's also rushing between the negotiations. So we are very pleased to have her with us. Juliana Marcucci is the Climate Policies and Carbon Markets Manager at La Clima, and a lawyer specialized in climate law, environmental law, and ESG practices. She's part of La Clima's team that monitors international climate and biodiversity conferences, and she also holds a PhD in environmental law from Pace University and a master's degree in international business law from Utrecht University, and has been worked with us at the Hague Conference as well as a technical expert on carbon markets. Ms. Juliana.
Thank you, Raquel. Hi, everyone. It's a great pleasure being here. And before I introduce myself, just want to say, and before Eduardo leaves, what a great challenge you left me, because I had a really inspiring speech from Jerry. I have a really explanatory speech from Eduardo. So I was thinking here, oh my gosh, what should I do? And how should I be useful to this conversation we are having? As Kel said, I'm from La Clima, and La Clima is an organization that speaks with many players, with many stakeholders. So we have this connection with civil society, we have this connection with academia, with international organization, with the government, with law practitioners, with lawmakers, financial markets. So we are glad to say that we have this holistic overview of the market. Me personally, I deal directly with projects concerning public policies on carbon markets and with great focus on the Brazilian markets, the voluntary and the compliance one we just launched by the end of last year. And also, I'm here because I'm part of La Clima's delegation that follows on Article 6 negotiations. So, my idea here, if you allow me, is to bring illustrations of what both of them just talked about. So, how we take such a technical and legal subject as international private law and bring it to the daily basis of a carbon market. And here I just propose you to think, for example, of nature-based solutions, RED plus projects, which is what we have most here in Brazil. Well, we are talking about several players in a chain for issues of a carbon market. So let's think about RED plus projects. We have the owner of the land, we have the indigenous and local communities that are impacted by this project, being within their territories or if they are nearby. You have the project developer, you have the expertise that is going to design the whole thing. You have the project investor, being the national one, the international one. You have the monitoring lawmakers and law compliance monitors. You have also the buyers, you have the traders, and you have a lot of other indirect stakeholders connected to this whole supply chain. So there's a lot of things on the table to think about, but again, illustrating here, after we had the whole supply chain in our heads, what is really important here when it comes to, for example, RED plus projects? Well, we have the owner of the land, so we are talking about land tenure. So we are talking about how the rules, the local rules for land tenure, land ownership, and carbon ownership, with this a term that we're using a lot in this field, which is who owns the carbon credits from this kind of project. What law says that? And we have countries, we have jurisdictions that says that. We just created our own here in Brazil. And you have places where you are not dealing with any legislation that makes it clear who owns the credits by the end of the day, and also who owns the lands. We are here in the Amazon. I'm so proud of saying that at a COP. So we are in the Amazon. We are in the state of Pará. And here is a place known for have 4 floors. What does it mean? You have a lot of difficulty and a lack of clarity when it comes to land tenure. And this is just only an example. You have this in the whole world. So you need clarity on who owns the land and therefore who owns the rights over the carbon credits they're going to be issued. Well, that being said, we are looking for international private law. And when you are going to a cross-border commercial transaction, for example, or you are going to a bilateral agreement between countries to selling and buying ITMOs, or you are going to a Article 6.4 transaction, you are dealing with this kind of things. You are dealing with the ownership of the credit, with the regularization of the land ownership as well. Well, now for a second topic that I wanted to share with you, benefit sharing. So besides ownership, we also have a bunch of rules that say who will be entitled to the benefit sharing, being it monetary or not. You have a lot of examples of nature-based solution activities that provide you with carbon credits that at the end of the day, if you don't have a regulation on it, they will just create a building in a local community that can be useless, or they can just create an infrastructure for some kind of nuts processing. I'm just using examples for my time being a lawyer and dealing with this kind of agreements. That it doesn't make any sense to the community because they don't deal with nuts, they don't process it. So it is really important to make sure that there is a positive impact, what we call social additionality to this kind of projects. And you have law for that. You have contractual and commercial agreements for that. And this all comes in the end of the day to this discussion. I'm trying to just fulfill a challenge here to connect our basic reality when we are talking about a project and this complexity that is international private law. And it's all interconnected. And I'm really relieved and proud to say that, because it's a difficult thing to put in a point of view. Well, so then we talk about benefit sharing, and then we have what we call FPIC, free, free, prior, and informed consent. So we have the International Labor Convention 169 that guarantees that if you have a local community, you have an indigenous community, and there is some kind of impact in their social living, their daily basis, in their business or whatever, they need to give prior consent. And for a community, and let's think again, we are in the Amazon. Let's think about indigenous communities. They speak other languages a lot of times, or local communities who has a really different historic tradition from someone that is buying credits, let's say in Italy. So you need to understand their reality. You need to make it accessible in their language. What are you proposing? What kind of project you are proposing, and how this is going to be beneficial for them, and how they can participate on it, because we are in their territories. So you need their consent. And for you to give a genuine consent, you need understanding. Okay, so what it has to do with law? It has to do that we have a raising movement to transcript it in this kind of guarantee, this kind of safeguards in law, in domestic legislation. And sometimes, I would say most of the times, the treatment is different depending on the region you are, depending on the country, and on the kind of legislation you have on the table. And also, you have, when it comes to FPIC, we are talking about the community. Who decides the whole thing? The community. So their protocols shall be followed. Their traditions, their culture, their rules shall be followed. And this is what law usually says. The first call is from the community that is being impacted. That therefore you need the whole chain to take a look at this, to put this into consideration, for you to have equal, diverse, and just, as we are talking about climate justice, transactions and cross-border transactions. So this is the examples I wanted to give it to you of how to put what we are talking here in this complex, high of level complexity to the reality of those that are really impacted by carbon projects. And another point that I wanted to bring in my speech is what is going on here. Okay, so we say about the UNFCCC negotiations that Article 6 is a bubble. Is everything different? People are different there. They speak differently in negotiations. The pace is different. And that's okay. Different is good. But it makes it difficult to understand. And a lot of people ask me, what's going on in Article 6? Didn't it finish last year? I mean, didn't the whole thing finish in Baku? Yes, it did, and it did not. Because we concluded the set of the basic rules for the creation of the both carbon markets that are foreseen in Article 6, ITMO's market, and Article 6.4 called PACM, which is pretty much a global voluntary carbon market. I don't like to say that it replaces CDM, because it's much more than that, and I'm not undermining the all of the shine of CDM, but it's a whole other thing. We're talking about a global market that is set by UNFCCC, whose rules are being set by the supervisory body of this mechanism, which is a formal body created under the UNFCCC umbrella. It is a it is a group of 12 people representing the whole world. So it's quite a difficult challenge to make rules of a global carbon market in just a body under UNFCCC. And we are also talking about ITMO's market, which is a market that is going to be set by the participating parties, the countries. So each of the country that is interested in participating on buying or selling ITMOs, they need to set their own rules. Can you imagine how how hard it will be when disputes come, when differences come? So this is all connected to international private law because we are stepping into a phase of Article 6 where countries, organizations, multilateral organizations, World Bank, developing regional banks are just talking here. They just finished the dialogues, what we call ambition dialogues yesterday, if I'm not mistaken. I just lost time track of time. That what are the challenges, what are being the difficulties, what are being the lessons learned, and they are putting a lot on the table. There's a lot of things happening, and I just when people ask me, I say they just have this reality check. Oh my God, this is more difficult than it seems. So now is the time where they are making the rules. And that being said, I will say your timing is perfect. So the Hague conference time is perfect because this is the time we are trying to harmonize rules. We're seeing the differences between countries, between regions. So this is the time for us to say, okay, how we harmonize the whole thing and how we make this useful and fruitful as everyone wishes. So that being said, I put myself in La Clima to all of your disposal if you want to learn more about national carbon markets in Brazil or what is going on in Article 6 negotiation rooms. And again, thank you so much for this partnership. It's been a really beautiful journey for me. Thank you.
Thank you. Thank you very much. Yeah, so we do have a bit of time, and we wanted to check if anyone wants to pose questions, and it's also fine in Portuguese, what you feel comfortable with. Um,
Hi there, Moritz van Onger. I am. I work as a lawyer in the field. I'm also part of the expert group, so I'm very committed. So thank you for being here and for sharing and for introducing so nicely all the different dots because it is so complex, as you said. I have two or three questions. One is, Jerry, maybe we could explain again because I think it's very important what the toolbox is that HCCH provides in terms of, it's like soft law, hard law, how relevant it is. And then the other one that's maybe a little more complicated is since we are in this environment where it's probably no longer appropriate to say, oh, there's volunteer carbon market on the one hand and compliance market or Article 6 on the other hand. So to what extent does that impact your work, given that there's so many exceptions and, it's like in terms of, oh, there's, it's like there's all this public law space that we don't want to touch. Is that, can we still access this? I know there's right now, it's like a lot of discussions on voluntary verified credits, but does that impact also the work, the trade with any of the compliance well, it's like the units being also, it's like looking what's happening in practice is that many projects are now trying to generate credits and also reserve the right to turn them into, with a letter of authorization, into some form of, credits that are then recognized under the Paris Agreement. So how does that impact the, the way you look at these trades and these property title?
Well, thank you for your question. Before it speaks, I'll just give a little perspective from La Clima side in our function before civil society, because I really need to leave. I'm so sorry about that. But in our view, what is important is to leveling the debate. So what La Clima does is to take this bunch of different legislations, different rules, different guidance from the voluntary carbon market, and to level the debate with all players involved. So we've been performing some projects here in the Amazon, indeed, any other regions of the country, to talk to popular attorneys from local communities, from indigenous communities, for them to have a practical and legal view of what these rules are and what they say about their safeguards, their rights. So mainly what we do here, what we think we could check the boxes is to leveling this debate. And the same goes for Article 6. One of the main discussions we have in the negotiations room in this COP is how to provide clear and efficient capacity building to all players, especially Global South. And for this is besides being really expensive, this is what they are discussing in the room, is where do they get the money for this, is how to harmonize all of the rules from local projects and how to harmonize all the markets to make it profitable, in the sense that one credit that is issued here can benefit a project or an ambition of another NDC, and so far and so on. So I just wanted to close my contribution by sharing with you an example that a few days ago, Brazil launched a coalition that has the intention to harmonize all of these discussions concerning carbon markets. So methodologies, accountability, rules and guidelines, among other aspects such as MRVs of different carbon markets, to make this stronger and to make it clear for all players, and consequently to make it just for all of them and equitable. And this initiative has been really well accepted by other countries. So I think besides your initiative, which again I'm so proud of and happy to be connected to, we have a lot of initiatives from other fields, from other styles, from other countries that intends to harmonize all the carbon markets to bring justice to them. Thank you.
Thank you very much, Juliana. And I'm just going to take maybe the other question that Maurits put forward. It's a good question. So we have a very complicated name. It's called the Hague Conference on Private International Law. We were founded in 1893. So we're very old as well, 130 odd years. And our work really focuses on creating frameworks to address these private international law issues. Now, the toolbox that Maurits refers to is the things that we come up with, right? So the deliverables that our members do. We're a multilateral, international, intergovernmental organization, much like the United Nations. So we have a group of members that come together. So we have more than 90 member states and the European Union sitting as well as a member. What do? We have an entire spectrum of deliverables. It starts from things like guides to good practice, things that explain, explanatory notes, draft notes that we put out to say, okay, look, these are the papers that you might want to look at before you enter into these things. We go on to soft law principles. So we have, for example, in 2015, concluded the principles on the choice of law in international commercial contracts. So those are soft law principles. They deal only with private international law. They provide some sort of guidelines that you can or choose not to take on. And then we have a whole stable of 40 different conventions. These are treaties, and these are binding on states that sign up to the treaties or to the European Union. I'll give you an example. We have, for example, the 1996 Convention on the Protection of Children, and this deals with cross-border jurisdiction, the law that would apply. It includes things like safeguards and the recognition and enforcement of decisions relating to children who find themselves outside of their borders of nationality or outside the borders of habitual residence. We have all these things to protect children. And if our society cannot protect children, what can we do, really? It's the most vulnerable of our people, the most important. And now we're doing the same thing for carbon markets, acknowledging that there are all these private law initiatives, which are important because they harness global finance to not just meet climate ambition, but also to create new avenues of revenue for the global south, for the communities on the land. we have all of these different kinds of frameworks for jurisdiction in particular. So to decide which court would have would be the right forum to hear a dispute, and for the recognition and enforcement of decisions, generally conventions are necessary because parties or states have to agree. What's great about conventions is this: you get states together to a table to say, I will recognize your decision, you will recognize mine. What does that do? It builds trust between states. And that's so important because otherwise you get a decision, you can frame and put it on the wall. That's about all you can do, essentially. But what you need to do is enforce those things. So those are the toolkits of things that we have. It ranges from everything from guides to really practical handbooks, all the way through to treaties, soft law instruments, such as principles. But for the carbon markets group, and actually Moritz sits on our experts group as well, that group really were aiming towards creating a framework. We haven't decided, I think, the form of that deliverable, but we're really now considering how best to move forward, keeping in mind all of these issues. Now, our conventions, of course, include safeguards. They include exceptions. And in particular for the carbon markets, this is so important. Just like the protection of children, we're also protecting the communities and the land. I hope I answered that question. Would anybody else like to follow up? Yes, please.
Hi, my name is Anna. I'm a co-founder of a company. We develop carbon credit projects, and also I'm a master candidate. So I study carbon market credits. And I would like to ask you something about how do you see the tax structure can stimulate the carbon credits generation, and how do you see if there's a perspective of an international tax structure, like the countries doing the tax about the carbon credits to stimulate also the generation and the selling of the carbon credits? Do you see it's there something?
You mean the text of the draft?
The tax, the
Taxation. Ah, okay.
Thank you for the question. And I think what's also important about private international laws is just to kind of mention that we're not experts on taxes, for the reason that that's quite a sovereign issue. So most states decided themselves. What's special about private international law is that it does not impact the domestic rules at all. So what we do is just simply create the bridge between two jurisdictions, and we say which one would make more sense. That provides the legal certainty. Taxes is something that, depending on the jurisdiction where your company is seated and so on, will be a sovereign issue. We don't touch that for the moment, although we have had, separate from this project, a proposal or maybe a question raised as to whether we should have a convention that talks about tax status and taxation across borders. We're not there yet. And the question that you asked specifically, I think it will make a difference. It's just for us at the moment, it is a sovereign matter that we don't touch. So I'm sorry, we can't answer that particular question. Thank you.
If there are any other questions someone would like to raise.
Thank you. Just a quick one. I would like to know your perspectives about Article 6 implementation. How do you see it in Brazil, and how long it will take after this COP?
Thank you for that question. I'm going to turn over to my colleague, who is the technical expert on this. Maybe she can answer that question, Raquel.
Of course. Yeah, so we have to be very careful to answer that because, of course, we answer for the work of an international organization, so we cannot speak on domestic implementation of Article 6, but perhaps Article 6 of the Paris Agreement. But perhaps what is important to say from our side is that and I think Juliana also touched a bit on it, our Deputy Secretary General, also Eduardo, is that it's a very important moment for these discussions we are having, because now that the countries are going into implementation status on Article 6, there are a lot of arrangements being made between states and also with private actors functioning to have credits that can have the label of Article 6. So that's the part where our project on private international law is interested in, because you will have private actors commercializing credits or participating on credits that may have the Article 6 label. So that's where we can look, because we really look into the relationships between particulars, right? So transactions between private parties. But and then the implementation, what we've heard from some COP debates and also from the previous bond gathering, is that countries are very interested in understanding how they will do this, right? So they've mentioned before learning by doing, because it's a lot of learning and a lot of exchanges between countries on how they're going to implement them. But we are sure that there will be an impact from the private sector activities, and that's where the public and private intersect, and which is very important for our work.
I would just like to thank you for. Oh, we still have a question before? No questions. So I'd like to thank you for the brilliant, very didactic, very clear presentations and for your presence here today. It's an honor for us from the DPU to have you here.
Ok, tem uma informação importante, todo mundo que assistiu, se quiser o certificado, tem um QR Code que vocês podem usar se quiser o certificado de participação. Obrigada a todo mundo agora em português.